I'm fine.
Have the appellees decided how they're going to split their time? You're muted, Mr. Van Clear.
My apologies, Dan Van Clear. If we're allowed rebuttal time, I'd like to reserve 3 minutes for rebuttal. We do have a cross appeal.
You have a cross appeal, sure. And are you need to split your 20 minutes? Are you both going to argue, or are you just?
No, sir. It will just be myself.
Okay, sure, that's fine. All right. Okay, ready, Mr. Ketching?
Your Honors, good morning. Judge Northcutt, I respectfully request 5 minutes for rebuttal.
Sure.
So my initial argument will be 15 minutes.
You got it.
Your Honors, this case presents 3 bedrock principles of common law applicable to contracts and agreements affecting real estate. The first principle is that a contract with an indefinite duration is terminable upon reasonable notice. The second principle is that an agreement with indefinite duration that negatively affects the improvement and marketability of property is avoidable. And the third principle is a contract which lacks a remedy for a party is avoidable or terminable for lack of mutual remedies, not lack of mutual consideration, but lack of mutual remedies. This case also presents a question of whether there was a question of fact that the court should have decided with respect to the length of barges, and I will get to that in a moment. But focusing on the first 3 principles at this time, our request is that Your Honors reverse the judgment of the circuit court and remand for a consideration of equitable principles and the reasonable time to basically terminate the port agreement. Now, count 2 of the counterclaim presents the equitable claims of the defendants, and we're asking that there be a remand for a consideration of those items. But not to leave the impression that the equities are strictly on the defendant's side. The overall equities, and I'm just going to touch on this just for a moment to make sure that Your Honors understand that there are equities on the plaintiff's side, even though we are seeking to terminate or avoid certain agreements that were agreed to back in 1996. At this point in time, Your Honors, the port agreement is getting ready to be abandoned in part, or maybe in full, depending on how you look at it. Gandy View and CFI have operated this facility for over 20 years. The equipment that relates to the caustic soda and the chlorine for purpose of making bleach is at its useful life. And even on the books, this multi-million-dollar investment has been reduced to a book entry of $500,000. And most importantly, it is stipulated and understood by counsel from the defendants that once this plant is closed for bleach production, there will be an 80 to 90% reduction in the use of the pipeline and the port. So the equities in this case are not totally on the defendant's side. And most importantly, it is undisputed that Gandy View and CFI, the appellees, intend to abandon this plant, at least with respect to bleach production, which is what the caustic soda and the pipeline is used for, and move it to Manatee County. So having said that, Your Honor, I'd like to turn to the first principle of law, which is termination upon reasonable notice. And in that respect, I would direct Your Honor's attention to the Florida Supreme Court decision in the city of Homestead. The Supreme Court in that case talked about the precedent among the Third District Court of Appeals, the Fourth District Court of Appeals, and the Fifth Circuit Court of Appeals federal with respect to termination, and basically adopted the thinking and reasoning of those courts. And in doing so, the Supreme Court said that the Gulf Cities case and the Florida, Georgia case, which is a First District Court case, hold, quote, that a contract for an indefinite period, which by its nature is not deemed to be perpetual, may be terminated at will upon giving of reasonable notice, and went on in illustrating the points of this bedrock doctrine, quote, these cases involve contracts where the courts were unable to construe a period of duration from the circumstances surrounding the execution of the agreement.
But why can't we construe that here? Why can't we construe the period of duration as the trial court did to mean so long as Gandy and CFI are using the property for the purpose which they bought it? You know, sort of consistently with the city of Gainesville case for the duration of the going concern.
Your Honor, let me put the city of Gainesville case off to the side for it. I'll come back to that in just a minute and go to the initial part of your question, which is why can't the second DCA interpret this port agreement like the trial court? Respectfully, Your Honor, this court cannot do that because the first step is to look at the port agreement itself. The port agreement itself contains no duration provision. The closest thing that comes to the port agreement is in the port agreement to duration is paragraph 28 of the port agreement, which specifically says that this port agreement is to bind the assignees and the successors to Gandy View and CFI, indicating that there's no termination with respect to when Gandy and CFI decide to stop one of the operations at the plant. That express statement in the port agreement basically prohibits this court from going behind it to determine extrinsic evidence pursuant to the ruling in the Gulf Cities case, and also the other cases where these types of agreements are presented. The parties rely on the agreements, they perform them for 10, 20, 30, 40 years. And then at that point in time, there's either the development of an unreasonable restraint or because there is no duration, one of the parties elects to give reasonable notice and terminate. Now, the city of Gainesville case stands as an outlier to this, this particular proposition, and that's enunciated by the Supreme Court's decision in the city of Daytona, which restricts the city of Gainesville case and the city of Daytona case to contracts that exist between a city, Supply and Water, and others. That is not the factual circumstance here and therefore does not control. I hope I answered those questions. So if I may proceed, after reading these quotes from the city of Homestead case, where does it take this panel and where does this take these parties? First of all, Your Honor, like I said, first thing is what does the port agreement say? Does it say anything about duration, but suggests that it can go into perpetuity from one assignee to one assignee to one assignee? On the extrinsic evidence, which I just talked about a minute ago, there is only one set of extrinsic evidence applicable in this case. The testimony of Robert Namoff, who is the CEO of CFI and Gandy. He signed an affidavit saying it was the intent upon entering the port agreement that it would be terminable, or rather it would end when CFI and Gandy View no longer wanted to use the operation. That testimony was contradicted by the CEO of Rattlesnake, the predecessor to Viper, who said in questioning directly, without any leading questions, that he said, quote, the duration of the agreement was indefinite, and almost verbatim quoting him, not only is it indefinite, but I really think Gandyview didn't even have to operate it for the agreement to continue. Now, the point is that at this point in time, as a matter of law, with a de novo review, it is incumbent upon this court looking at the port agreement to enforce its terms and to follow the precedent set out in the Southern Bell case, Fifth Circuit decision, in the Gulf Cities case, Fourth Circuit, Fourth DCA decision, and the Florida Georgia case, which is a first DCA position, as well as the Collins decision, which was rendered by the Second District Court of Appeals back in the 1960s. That leaves a question, though, that the court needs to consider: is this a permanent agreement? Because in City of Homestead, the Supreme Court said, in trying to determine whether it's an indefinite agreement or a permanent agreement, one should look at the surrounding circumstances. Now, in the City of Homestead case, there was a contract that divided up the territory between Florida Power and Light and the City of Homestead. That was a settlement agreement of a dispute. After it was signed, there were no further obligations on either party, whether it was Florida Power and Light and the city, to do anything with respect to performance or take any acts with respect to that territorial division. As well, the court noted that it was a settlement agreement that had been approved by the body that had the authority to deal with those matters, the Public Service Commission. That kind of situation does not present itself in the appeal before your honors. This is not a permanent contract. And my last—
let me stop you for a second, because I think that sort of gets into, this case sort of presents an uneasy combination of not just contract law, but property law. And I'm not sure, I mean, your position is any property rights in an easement are secondary to and governed by the contract, right? And so the contract prevails?
Your Honor, it's a little more specific that respectfully. First of all, the easements in this case specifically say that they're conditioned upon the port agreement and terminable when the port agreement terminates. So that's the first point.
I thought I read in the port agreement that the port agreement terminates when the port agreement follows the easement rather than vice versa.
No, Your Honor, if I may just pick up the easement and read one to you, if I may. There are two designations of a portion of easement which are applicable here. And in paragraph 8, they each read as follows. The designation termination, this designation terminates simultaneously with the termination of the port agreement referred to in paragraph 6 above. And in addition, the port pipeline easement has a similar provision that basically says that the port pipeline easement, there are 3 easements here, is governed by the port agreement as well, which I believe is reflected in paragraphs 6 and 8. In 8, it says, in the event the parcel 1 easement or parcel 2 easement terminates, this agreement shall also terminate and be of no further force and effect. The parcel 1 easement and the parcel 6 easement are the 2 other easements that contain the paragraph 8, which expressly states that it terminates with the port agreement. As a follow-up to your Honor's question, in the Southern Bell case, this was a real estate case where the railroad had given permission to Southern Bell to put telephone lines above its railroad tracks and below the railroad tracks. And they had operated that agreement, the railroad company as well as the telephone company, for about 40 years until it was litigated. And the Fourth DCA decided that because it didn't have a duration and because it was improper for the trial court to admit extrinsic evidence, that agreement was terminated, even though it basically involved easements, because the underlying agreement had no duration. A similar result occurred in the Gulf Cities case, where there was a developer of a subdivision and there was a provider of gas. The developer of the subdivision had built out the subdivision or was building it, and the provider of gas, using easements set up by the developer, installed the main gas lines. Years later, the supplier wanted to get out of the contract for one reason or another, and the court determined that it was terminable upon reasonable notice because it lacked duration. So these points of law that we're talking about, Your Honor, are underscored by the easements themselves and also underscored by the precedent dealing with these principles and real estate. So at this point in time, I think I need to say that taking the Florida Supreme Court summary of the Gulf Cities case and the Florida Georgia case and the Southern Bell and applying it here shows that there was a material mistake, a harmful mistake that was made by the court below.
Mr. Cassie, you're at your 15-minute mark, so you want to say your 5, you're at your rebuttal time.
I'm out of time, Your Honor.
Well, you're at 15 minutes. You can use your 5 as you wish.
I'll just use 30 more seconds, Your Honor.
Okay.
And I'll reserve. The lower court here, with respect to the port agreement, basically decided a duration according to what Gandy View and CFI wanted to do with the property. But it expressly found that the duration was indefinite. In multiple cases, the court here found that the duration that it employed was indefinite, which automatically should have required implementation of the first doctrine that we're talked about here. So, Your Honor, that's the close of my opening remarks, and I look forward to coming back. Thank you.
Mr. Banclair, you're muted. I do that all the time.
I apologize.
My colleagues wish I would do it more.
Dan Bandclater for CFI and Gandy View, the appellees, cross appellants, who were the defendants below. Gandy View purchased this property in 1996, and as the trial judge correctly found, the port agreement and the granting of the easements and the execution and the acquisition of the land was all part of one transaction. And one cannot simply look at the port agreement in a vacuum or in isolation. One must look at the entire transaction because these 3 legs of this 3-legged stool are all functionally intertwined. There was no dispute that Gandy View purchased this landlocked property solely based on the assurance that it would have access to the waterfront and the dock so that it could bring its barges of raw materials in for its manufacturing operations. But for that assurance, which is set forth in the port agreement and set forth in the easements, this transaction never would have taken place. And this, of course, was a very painstakingly negotiated transaction by the Carlton Fields firm on the one hand and the Battaglia Ross firm on the other hand. The port agreement is 32 pages, single spaced with 70 pages of exhibits. There are multiple easements, all of which were duly recorded and filed in the public records. And the parties did everything possible to assure that Gandy View and its affiliate CFI would continue to have access to the dock and the waterfront.
For how, Mr. Banclater, for how long?
For how long?
That's really the key question. For how long?
The answer to that is, as the trial court found, as long as Gandy View and CFI continued their manufacturing operations and needed to use that dock for those operations, plus 6 years. Why is it plus 6 years? Because in the event they were to stop using the dock and the waterfront and stop bringing in barges, should 6 years go by it would be deemed an abandonment and the easements would terminate. That was there for the protection of Viper Ventures. Why would they have a 6-year period? I don't know how they came to that, but I suppose if the plant needed renovations or needed to be rebuilt, but they just wanted to assure that a short-term lapse in usage of the dock wouldn't result in an abandonment of the easements and the port agreement. There are 2 cases upon which Viper Ventures relies for setting aside this carefully negotiated agreement. One is the Eaglehart case, and the other is the PV case. And this concept of unreasonable restraint on alienation is very different than what Mr. Ketchy just told your honors. It does not apply when an agreement, to use his words, negatively affect the marketability of the property. That is not the case, and that is wholly inapplicable. Judge Stevens mentioned at some of the hearings that he has a utility pole in his front yard that he would love to get rid of. It blocks his view, it impairs the value of his property, and he could probably get more if he were to get rid of that utility pole should he sell the property. But just because an agreement negatively affects the marketability of the property or its value doesn't render it void as an unreasonable restraint on alienation.
At what point do we look at it to determine whether it's a reasonable or unreasonable restraint?
Well, I think the key is, and Eaglehart doesn't really define what's reasonable and what's not reasonable, but the key is whether the agreement unreasonably restrains the free alienability of the property. Now, it's undisputed that in this case, factually, there is no restraint on Viper's ability to sell the property. Viper has had multiple offers, all of which are in the record, offers for millions of dollars more than it paid for the property. And in fact, as your honors know from Viper's recent filing, the property is currently under contract to be sold by Viper. And that was disclosed simply as a matter of candor to the court. It was not in the record, but Mr. Ketchy did disclose it. So we have to look at what the Viper property consists of. The Viper property has multiple tenants. It has Cargill food processors that occupies a portion of it under a lease. It has Titan concrete manufacturers. It has Screamin' Willie's restaurant. It has Trident Yachts, the boat manufacturer, American Bridge Company, which is a contractor that's involved in renovating the Gandy Bridge, and Kevitt Construction. And it obtains market rents and market rate leases from all of these tenants. And the business that the CFI wharfage and dockage comprises or consists of is a very, very small part of Viper's total operations. In fact, Viper collects over $1 million in rent from these other tenants. And that's in the record in the deposition testimony and the report of Viper's expert, Mr. Not Eschenbaum, I'm sorry, Engelman, Mr. Engelman. So this is a very different situation than what we had in the Eaglehart case, where you had one family living in a house with a pasture and a farm who were precluded from selling their land to anyone other than the original seller from whom they bought it at a fixed price. And this is very different from the PV case, where the property was occupied by one tenant who had a perpetual lease at a fixed price that could only increase by $50 per month every 2 years, and there were no other tenants on the property. Viper's property has multi-tenants located on different parts of the property. Those leases are renegotiated from time to time. Those rents increase. And by the way, the wharfage and dockage fees that CFI pays also increase, and they adjust with the market as established by the Port of Tampa and the rates that the Port of Tampa charges. So this is a very, very different situation from Eaglehart and PV, and those cases are wholly inapplicable. Now, with respect to the issue of whether this port agreement is terminable at will, the irony, of course, is that this agreement was very carefully written to prevent Viper or its predecessor Rattlesnake from doing exactly what they are now trying to do. which is terminate this agreement upon reasonable notice at their pleasure. That was never the intent, and that's not what the agreement says. Unlike the cases that Mr. Ketchy has cited on this point, the port agreement has very specific termination provisions. And they basically say that the contract can be terminated by mutual written agreement. It can be terminated by Gandy view upon 30 days notice. It can be terminated based on an uncured default, or it can be terminated if there is an abandonment of the easements for 6 years or more. These things were very carefully negotiated. The one thing that clearly is not in the agreement is the one thing that Viper wants this court to now write into the agreement judicially, and that is to give Viper the unfettered unilateral right to cancel this agreement upon reasonable notice whenever it wants. It's clear that Gandy View never would have purchased this property and never would have spent several $1 million constructing a manufacturing facility if that had been known to CFI and Gandy View. And by the way,
Is City of Gainesville your strongest case?
Well, I think City of Gainesville and City of Homestead. The City of Gainesville was not limited to just water utilities and service to cities. The Supreme Court never said that. If it had wanted to say it, it certainly could have. In the City of Homestead, I think the most important part of the holding in that case is that the Supreme Court in that case said, if a period of duration can be inferred from the nature of the contract and the circumstances surrounding its execution, the contract is not terminable at will, and the court should give effect to the manifest intent of the parties. The manifest intent of the parties in our case could not be more clear, as the trial court found, and in fact was undisputed. And just so we're clear on this, there was never any claim below, and not one scintilla of evidence below, that the intent of the parties was anything other than what I just said. That is to have this agreement remain in effect as long as CFI and Gandy View operate their plant and need to use that dock to bring in their raw materials. There was never any evidence offered to the contrary after 7 years of litigation. As to whether the, well, let me cut to the chase here. Viper, their expert, Mr. Engelman, said that their property would be worth $11 million more if our pipeline were not there. Okay, we didn't challenge that. Mr. Engelman says with the pipeline in place, the property is worth $22 million and can be sold at fair market value for $22 million, which is $10 million more than Viper paid for this property in 2004 and 2005. The reason it would be worth $11 million more without our pipeline is the pipeline obviously takes up some physical space. So instead of being able to build 1,100 units, condominium units, Viper would only be able to construct 900 some odd units. And that's why you have the $11 million difference. But even Mr. Engelman, who is Viper's expert, does not say that this property can't be sold or that it can't be sold for its fair market value. He put a value on it, $22 million. And in point of fact, it's in the record, Viper Ventures has been offered $29 million by Key International to sell the property. It was also offered $20 million cash by an industrial developer named Horowitz, and that's in the record too. There have been many offers to purchase this property. Viper simply wants to do away with our agreement so that it can get more money than what it would otherwise get. And the concept of unreasonable restraint on alienation of real property was never intended to do that. As this court said in the AC Associates case, the law does not permit the cancellation of property restrictions for the purpose of accommodating the best or most profitable use of a piece of property. That's not how it works.
At the time Rattlesnake entered into the agreement, it actually was a very good deal, I would assume, because they had this landlocked piece of property that would have been in an industrial area that theoretically, nobody would have bought if they couldn't get access to the water. I mean, is that a fair statement?
You'd hit the nail right on the head, Your Honor. This is the landlocked piece of property. The rest of the property is all waterfront. One of the ironies in this case is this agreement did not restrain the alienability of property or discourage the development and improvement of real property. It did the opposite. It facilitated Rattlesnake's ability to sell that landlocked parcel that nobody else would have bought. And it resulted in CFI constructing a multi-million-dollar plant, employing 40 or 50 full-time people, and providing essential water treatment chemicals to most of the cities in Florida to treat their drinking water and wastewater.
And that's why I asked, at what point do we look to the reasonableness or unreasonableness of the restraint? Is it the time the restraint is imposed, or is it down the road when circumstances have changed?
Well, in Eaglehart and Peavy, they looked at it at the time that the restraint was imposed. But I don't think it would make a difference one way or the other in this case, because
maybe not. I mean, it very well may not. Just as a matter of law, I was curious as to your position on that.
Right, because as I mentioned, this property can be sold tomorrow. In fact, it's already under contract to be sold. And the price at which it's under contract to be sold, according to Mr. Ketchy's filing, is $9.9 million for 6 acres, which if that carries out to the remainder of the 30 acres, that's $50 million, far more than Viper paid for this property in 2004. So it's just a eureka moment how they could contend that our agreement has adversely impacted or restrained their ability to sell their land. As the trial court said in the summary judgment order, this is the elephant-sized hole in Viper's case. That Viper claims that having purchased this property in 2004, subject to the port agreement and subject to these very same easements, it now is unable to resell its property because of the very same port agreement and the very same easements. It just makes no sense. And the law was never intended to provide a party like Viper with the ability to cancel these real property interests, these easements, and this port agreement simply because it might be able to get more money. It would be able to get more money for its property. These concepts of unreasonable restraint, terminability at will, they just do not apply. Briefly, the terminability at will argument is dispelled by the City of Homestead case, the City of Gainesville case, the City of Daytona Beach case. 3 Supreme Court cases all come down squarely in favor of CFI on this issue and against Viper's claim. I think the AC Associates case out of this court, the 2nd District, is very instructive, although that dealt with a restrictive covenant. But we're dealing here with easements, which are granted even more protection. And this is very akin to a case that was cited by the learned trial judge in his order. I believe it was David versus Tatum, if I have the name right. And that was a case in which the seller told the buyer, I'm going to give you a license to construct an automobile dealership on parcel A, and you can have your drainage run off onto parcel B. The buyer constructed the automotive dealership. A dispute arose years later, and the seller wanted to vitiate that agreement. And the court said, you know, when you grant a license and a party who buys the property in reliance upon that license then constructs substantial improvements at substantial expense on the property, that license becomes irrevocable. And that's what we have here. Viper does not have the right under any theory to revoke this agreement. We have several issues that we raised on our cross appeal. Obviously, those only become relevant in the event that this court were to reverse in whole or in part for any reason. We obviously hope that doesn't happen. I'm prepared to save the remainder of my time for rebuttal, but I will answer any questions that any of your honors may have. Thank you.
You're right at 3 minutes left, Mr. Van Plater, so you predicted correctly that that's what you would
You're
want.
good. Okay.
Okay, Mr. Ketchy?
Thank you, Your Honors. this argument made by Gandy and CFI underscores the main point that I made at the beginning of my oral presentation. Their position is that irrespective of the case law, they have an equity in their favor. And he recites fact after fact after fact to justify this equity. But the Supreme Court in Eagleheart specifically said that the equities are to be determined in a different phase of the trial. You determine, for example, in an unreasonable restraint case, the unreasonable restraint, and then you determine the equities and determine there should be compensation. In Eagleheart, the party who had the right to purchase gave up 300 acres to the other party and received consideration of somewhere between $10 and $100. 300 acres, got less than $100, and 20 years later, the Supreme Court provided that that right of first refusal, that option, was to be terminated and avoided because it interrupted not only the free alienability, but basically the marketability and improvement. So what's done on the front end, just like in the Southern Bell case, doesn't control here. This became evident in your decision in the Bryan case, where you set aside a contract, an option to purchase, even though the option holder had spent money on zoning, had paid the taxes and what have you. You specifically said, the second DCA said, that part of the case is to be determined in terms of equitable compensation later on. Moreover, very quickly, many of the facts that Mr. Banklater said, respectfully, we don't believe are exactly true. First of all, in the Eagleheart case, Eagleheart did not talk about inability to sell the property. Eagleheart said, quote, the validity or invalidity of a restraint depends upon its long-term effect on the improvement and marketability of the property. Quote, the rule against unreasonable restraints is principally concerned with the duration of a restraint on the property than the time of vesting. Now, yes, we have looked to sell this property for over 20 years. It hasn't happened yet. The negativity that results here is apparent in Martin Engelman's appraisal work that said that because they're docking these vessels 330 feet more, they are unloading dangerous chemicals. And in addition, the payment of about $10,000 a year is not dependent on the market value whatsoever. That there was a restraint on what could be developed in terms of the number of units as well as the price that could be obtained. There was a statement that we received $1 million a year in rent. That's not true. We outlined in our brief that that's not the case. Council first focused on the manifest intent. The manifest intent of this agreement, as evidenced by its express wording, is that it didn't have a duration. It was indefinite. He made the point that this, and this is an interesting point. Of course, it goes back to the facts, which is where we are, which justifies remand for sure. This port agreement was negotiated by sophisticated attorneys. It's not in the record, but it's fair to say that those attorneys were perfectly aware of this point of law about contracts terminable when they don't have duration, as well as understood the unreasonable restraints. The parties didn't enter this agreement naive of what they were entering into.
Hey, Mr. Ketchy, you're right at the end of your time, so you need to wrap up.
I think I've made my point, Your Honor. Thank you.
Thank you both very much.
I still have 3 minutes.
Oh, I'm sorry. I totally forgot about you, Mr. Bant.
All right. I won't need the whole 3 minutes, but thank you, Your Honor.
Right ahead.
With regards to what I said about the $1 million in rent that Viper collects every year, that is a fact. You can find that in the record at page 3357. It is set forth in a chart of all the rents that are collected by Viper each year prepared by Viper's expert, Mr. Engelman. And again, it's in the record at page 3357. With regards to that Southern Bell case that Mr. Ketchy mentioned, one of the deciding factors in the Southern Bell case was the court's finding that Southern Bell had done nothing in reliance on the agreement. There was no detrimental reliance, and therefore they were not as reluctant to set the agreement aside. And finally, I just want to dispel the notion that CFI is vacating the premises and moving to Manatee County. That is not what's happening. We are building a plant in Manatee County for the production of bleach only. That's all that will be done at that plant. The CFI operation in Tampa does three things. It manufactures bleach, it repackages liquefied chlorine gas that comes in by rail cars, and it repackages large volumes of sodium hydroxide, also known as caustic soda, for resale to water treatment facilities. The sodium hydroxide or caustic soda operations and the chlorine operations there will not be affected by the opening of another plant down in Manatee. And the bleach production will continue in CFI, but there will be less of it. It will be at roughly 10 or 20% of what it has been thus far. If your honors have no further questions, I will rest now, and I thank you.
Thank you both very much. Interesting case. Brought back a painful memory, that being the AC Associates case, which was mine 36 years ago. Judge Lehan wrote that the persuasiveness of my arguments made it difficult to rule against my side, but it didn't seem to hold him back.
We may leave, I understand, Your Honor.
You're done.
Thank you.
Thanks, Mr. Ketchy.
Have a good day.
Good to see you both. Okay, our next case. I'm going